Our next speaker is Clive Baldwin from the Human Rights Trust, and Clive is going to talk to us about the first case of Indigenous people's land rights in the African human rights system, and this is in Kenya.
Well, good morning everyone, and congratulations to you all on turning up on a Sunday morning to talk law. I'm the opposite of Philippe. I'm having to rush off straight afterwards to a flight to Jordan, but I'm really happy to be here. And especially to see my former colleague Carla Clark, who's speaking this afternoon, when we were both at Minority Rights Group. I'm going to talk about a case that Minority Rights Group was involved in when I was working there before I was at Human Rights Watch, which began in 2002. It concerns a people in Kenya called the Enduroys. The Enduroys are a pastoralist community, meaning they move around with their cattle and herds. Traditionally have occupied land in the centre of Kenya in the Rift Valley. For many years they were quite lucky in that their land, under British rule, and that their land is not agriculturally viable, so the British weren't interested and the white settlers, the British brought with them, weren't interested. But the Enduroys were unlucky in that the centre of their land, or their home, was the Lake Bogoria, which has a lake which has the biggest amount of hot springs in Africa. It's a stunningly beautiful lake. It's now has hundreds of thousands, if not millions, of flamingos on. One of the last times I flew into Kenya on the video Visit Kenya years ago, and you see this lake and the flamingos. That was unfortunate because they were also in the constituency of the former president of Kenya, Daniel Arap Moi, who was president in the 80s and 90s. And he saw this land and thought, this is prime territory for tourism. And this was a community that was very traditionally led by elders, by male elders, and were essentially, as the stories we would hear many times around the world, we work with Indigenous, were removed from their land under a nominal agreement in order to make way for a game reserve, which is essentially a national park. So it's classic to protect the animals, we have to remove the people. The real reason was for tourism, and Daniel Arap Moi then built a hotel just next to the lake for tourists to visit. So that went on for a while. In 2002, when I joined Minority Rights Group, that was partly to set up a litigation program. There's many issues I could cover here, but I will. One of the interesting parts of that is that was MRG had been around for decades, a small organisation working on minority and Indigenous people's rights globally, been a fairly typical human rights framework of writing reports. But their board and leadership thought we need to add some litigation to that, because that's a key part of the issue. So I joined in 2002. We hired a legal officer straight out of Essex University, and we looked for a first case, and then we asked, MRG had a lot of minority and Indigenous rights partners around the world, and we asked them, does anyone have a good case going forward? And our main partner in Kenya, a group called the Centre for Minority Rights and Development, said, well, other people we're working with in Kenya here are the Enduroys. And they had a case and tried to litigate and sue over this in Kenya, and the case had gone nowhere domestically. And they said, of all the people we work with, we think this is a good community to work with because they're the most organised. And this is a key point I found in working with them, is as a community, after, even by 2002, some decades of being evicted from the centre of their land, so they had land around it still, but the core of their land around the lake they'd been evicted from. So having gone through this, having tried to deal with it politically, dealing with the president, having tried to deal with it legally, domestically, they said, well, we need a different way of organising ourselves as well. They kept their traditional structure of elders, but also created a welfare council elected by the community, involving representatives of all communities. So by youth and by women were represented on that council as well. This is where the community organised themselves entirely without any outside interference. So the group we were in Nairobi said these are the most organised group we know. And we looked at it, I remember saying, well, we've got a few cases we could start with, but this also seems one of the best. And also, if we're going to deal with the land rights, we want to start with something less complicated. I mean, if you're dealing with land rights around the world, there may be other individuals, communities who've come in. Here there wasn't, there were just the animals left, the local Kenyan Wildlife Service and the local council. So it was the community against the state and the state authorities did, which made it easier. So we said, well, look at that. So we went to see them, and I just wanted to stress in how we got from there to 8 years later winning a case. Was at the beginning, any of us knew what we were going to do with it. We said, okay, there is something called the African Commission on Human and People's Rights, which is an African body. There's now a court, which was created a few years later. But then it was the only place to go with a case was the Commission. And if you've ever dealt with treaty bodies, it's UN, the UN is something like that. It reviews states, members of the African Union, for their human rights commitment. It has thematic issues, it has country issues, and it has cases. So we said, well, look at that. A few people we spoke to said, you could argue the case, but it won't work, especially because the core of your argument would be property, and property is an individual right. It's not a collective right, a people's right. Well, they said, well, no one's argued it before, we may try it. And the key I found over the years in working on this case has made me fundamentally convinced that one of the strongest rights in the world, bodies of right, especially on treaties, is the African system. Because the African basic human rights treaties are the most recent, generally. So particularly the fundamental treaty, which is it's called the Charter of Human and People's Rights. It has more people's rights set out than any other human rights treaty. But it also goes with the Women's Rights Treaty, the Convention on Children, refugees even. They all go further than a lot of other international standards on paper. So it's putting that into practice. But we said, we'll go to the Commission. We spent some time with the community at the beginning. And at that time as well, I have to say that the key for getting advice on how to do this, in many places around the world when you're a lawyer, you have someone who's trained you, someone can tell you how to go to this card and how to use it. The key was an organisation in London, it's a fairly small one then, called Interrights, which had been around for decades and had helped and advised groups, individuals around the world to take international human rights litigation, especially in Africa. And they were key. They were only had 2 laws in Africa. Very sadly, after I think 30 years, they shut down this year due to lack of funding. To me, that's a disaster. Human rights. This is effective funding. They achieved so much with so little. So, I've been saying to others, we need something to replace them. That's a side issue, but we would have never understood the procedure, and you don't understand it until you've done it. Without their assistance at the beginning. One other thing, just for a framing of it, is throughout of this, we were running on a relatively small NGO, on project funding, on a small budget. People would look and say, oh, this community, they've now got advisors from London, they must have unlimited resources. In reality, I think the most funding I ever had in a year for the whole legal cases project, globally, including staff costs, was £70,000 a year, which was less, and I used to work in private practice in legal aid work, was less than a normal legal aid case would have. That was back in the days when we had legal aid. So it was tiny, and that meant every single trip and everything we did, every time we decided to go to the Commission, had to be carefully thought about. So it was always working within the limitations, but that's where the organisation, the community, and they were utterly amazing in coming back to us. And that's also when, actually, we started that in 2002, so another critical factor found where we could not have done the case otherwise was technology, and I can just show you what this changed things. Once the community started having not just phones, but mobile internet, and we could email, that made it infinitely easier to prepare a case with very limited resources. Again, there was nothing, though, as I'll come to substitute though for going out and working and seeing the community and understanding it. Okay, so how do we get to 3 stages in an international case once we knew how the Commission worked, which I won't have time to go into, but 3 stages in this case we have was, first of all, admissibility, and that's just showing that you have a case. And actually, in retrospect, that was the most difficult, and I'm quite happy the Kenyan government was still not taking the case seriously at that point. Because their domestic case had got bogged down, so we could have shown that their case could still continue. I mean, so having a Kenyan law on board was quite critical. It's also interesting, when I sometimes say to law students, when I was working and studying in the States, in the US, when I discovered human rights, and I decided to come back to the UK to study law, to be a human rights lawyer. I didn't know what one was, but I wanted to be a human rights lawyer. And when I was studying UK domestic law, where you have to do all these different areas of law, the two areas I found most pointless, what I wanted to do were land rights and equity and trust. If anyone's studied law in here and how to do them. I think I want to be a criminal lawyer and defend the oppressed, but land law and equity and trust, they're all about making rich people richer. In this case, because it was UK colonial law which had been applied, and that's how Kenya was a crown colony in the UK, would come in and start grabbing land by applying its own law. It was both, obviously, UK land law. It was also equity and trust, because the way the UK applied, and you learn a lot about the British Empire this way as well, was they would kind of say trust, if you know, land or property is often done for the benefit of people who are not considered able to run their own property, children especially. And they would say, oh, the land is trust for the native people who aren't considered capable of running their own property. On Kenyan independence, it wasn't even moved native title, but still, certain areas, and in fact, they're not called backward there, although in other parts of the world they are. That was still the idea that certain groups, pastoralists and others, are still not capable of running their land. The land would still be trust, and that's how it was easily taken from them. So it was a bit of a change. So we got the admissibility through by saying there's no point in going forward. When we came to the merits, the key factors that we argued were, one, that the envoys are people. So this was a factual decision. If they have people, they're entitled to the people's rights of the African Charter. The African Charter itself, looking at it, it's pretty clear the African states that wrote it thought people's rights meant them themselves as states. They were the people. They didn't really think it would apply to individual communities within them. But we said these are people, and they have a distinct group. They have elders that is there, and everyone else recognises them as such. There's a lot of complexity in this, particularly when we're dealing with where it's the British have been involved and where they like to label people, which I don't have time to go into, but that was the key to say they were people. The second was they're indigenous. When we met the community first, we said, they just want to say as a lawyer, so we might want to make this as a separate right. I mean, the community themselves in Africa and Kenya would never have been called indigenous. But we said, you are the people, they are the people who were there in the legal phrase from time immemorial. They are there as long as they can remember. No other community can remember anyone else being in this particular land. So they are the classic international definition of indigenous. There was a long-running issue with African states that they would say everyone in Africa is indigenous, so therefore no one is. So some states deny there's any indigenous rights in African states. The tradition was to say everyone is indigenous, so they would say then we can't apply to any particular community, and therefore the states can take whatever they want in practice. This was changing, and that's a whole different area. I think this case was part of it, but particularly as Philippe mentioned, the UN declaration, which came through whilst our case was going on, and as an NGO, we were part of the lobbying for that declaration. And the key part of that was getting the Commission itself, the African Commission, which had already been addressing indigenous rights in different ways, and starting to actually go out and do missions and see it in practice, which makes a difference, not a theoretical discussion. And they attacked African states at the UN who were saying, in Africa we think everyone is indigenous. And they said, no, that our own work already at the African Human Rights Commission has been looking at distinct indigenous communities which do exist in Africa. And that actually stopped the African states opposing the declaration, which is a key part to it passing and being approved. So that indigenous was another one. Are they indigenous? Well, by an international definition they are. property was the key, as I said. They are the collective property using the inter-American jurisprudence which already existed, that they had it as a collective, and that it was not justified to evict an entire people to protect wildlife. They can protect the wildlife without evicting the people. And that was also other arguments that it was the right to culture was violated because and the right to religion, because this was their centre, their land and their religion, their ancestors are buried there, their religious ceremonies are in the lake, by the lake. And the right to health, because not only was evicting them and their property from this very fertile land around the lake detrimental to their health, it's also they lost access to some plants which they used for health, both for them and their animals. And finally, we decided to argue the right to development. It's in the African Charter as a people's right. The only legal documents it is in the African Charter, in the Arab Charter of Human Rights. But no, there'd been no litigation on it. And as Philippe was also saying, as Lloyd's side, are you going to argue a case or not? Is it a viable argument? It gives you an option. So again, we spoke with the community, said, do you want to argue this? We thought, and they certainly did, and said our development has been negatively affected. So then it was turning this right to development into a legal argument. And that was quite difficult. I shouldn't really say that in a university, but frankly, we didn't get much help from the academic community, because there's been a lot of academic discussion about right to development. And I said, yeah, but turn this into a legal argument. And what helped is when we were putting our merits together and we were spending our time really dealing with the property issue and the history and the indigenous side. That time I happened to have two brilliant law students as summer interns from Harvard. And they said to them, no, we're doing this, can you look at this afresh? And without starting, how would you argue the right to development? And just make a legal case for something which we can then argue some facts on to show that this has been violated. And they essentially came up with 2 points, which was it's both a substantive issue, has the community been negatively affected in terms of what their development is as they see it. It's their choice as well as how they wish to develop. And it's a process, have they been properly consulted in all this? So it's both in removing them from their lane for tourism, but also they've received any benefits at all from the tourism, let alone the benefits they wish. And we could show many areas where this was violated. And this was great, so I had that, and essentially that's the argument we put in. Essentially that's the argument that some years later the African Commission cut and pasted as the first ever legal ruling on the right to development in an international tribunal. So it was quite a good internship for those judges, quite a good impact they had several years later. Okay, so that's our submission. Then the second stage I mentioned in the 3 stages of the case in the Gambia, where the commission meets, is we also ask for a provisional measure. These are some things you can ask in international courts and say something so urgent is happening that you need to order the state to stop it generally. I mean, it's often used to stop people being deported or even the death penalty being executed on people. So in this case, whilst all this was going on, instead the community still had other land, then it had another unfortunate development for them in that they found rubies on their land, on part of their land, which in more classic cases of extractive industries and elsewhere suddenly happened that a company mysteriously was formed in Kenya, no one was quite knew who was behind it. They were mysteriously given licenses to explore this land for rubies. Just to explore. But the exploration rights seem to emerge large diggers and signs being put up saying private property, keep out, men with guns appearing in the air for the first time. And it was poisoning remaining water supplies of the community and also making it very difficult for their land or for their animals to go past. And so well, this is a bit more called, I think the technical legal term is trying something on in this case. We'll try this with the community. It's a land issue, and we're saying it's affecting the remaining of the land. I mean, they could have said you have to just file a separate case on this. But another easy thing we're definitely finding very overworked courts and tribunals like the commissions make life as easy for them as possible. I mean, that goes basically for any case you're bringing as an applicant, I think. But that's particularly important. We make it an argument, you make it step forward, the steps to say this is going to have irredeemable damage to the community and their land, and make, even if you awarded them their centre of their land, their laid back, it would be impossible if the rest of their land is poisoned. And we wrote it in a way they could easily cut and paste it into a judgment like that, and they awarded it. That's one thing. But the next step, which was quite unusual, was Kenya complied with this ruling. Or rather, although this, in some of these tribunals and in the UN treaty bodies, it's never quite clear, as Philip was saying with the ICJ, what's public and what isn't. It probably wasn't supposed to be public, but the Kenyan, let's say, it just got into the news in Kenya. It became front page news. In African court rules against Kenya for the first time. And then they started investigating who are these miners, why is this happening? And it was illegal anyway in Kenya because they didn't have any legal authority to mine, let alone start seizing land. And the Kenyan government was not very concerned, both for its domestic and international opinion. Whoever was backing the mining company was no longer backing them, and the community was demonstrating peacefully, and the mining company left. And the water supply was no longer damaged for that period. It wasn't the final settlement, but it was, to the community, a significant victory.
And who was, do we know?
So, behind it, I mean, they suspect it would be people in the government, but nothing was ever proved. During my time there, maybe something has come later. But so at that point, finally, the Kenyan government takes this case seriously, and the next time we're in Banjul, the Kenyan government had sent 2 lawyers, his most senior lawyer from the Attorney General's office. But then they offered to negotiate. And this another principle of the laws, and this is a key for me, at least for how you do strategic human rights litigation. You actually have clients, you see your client's interest no matter what precedent you may not want to set. Your client wants to set the precedent, fine, but this is like, you say to them, to actually have a negotiated settlement that the government implements is much, much better than you setting any precedent, which might take years to implement. So we agreed to negotiate in Nairobi. I said on our very limited budget, this was quite a significant issue. But we went to Nairobi. To me, it's one of my most frustrating meetings as a lawyer. Because after all this was set up, and it's finally that the government can negotiate. In some ways, it's still a fairly easy issue for the government to deal with because there's no one else on the land if the government owns it or the authorities own it. It wouldn't have been that big a deal for them to agree to discuss a way the community can return to their land. But instead, they just came. It was almost intended to intimidate us in the community at that point. That they had no authority to settle in any way, shape, or form. So I'm the colleague, and this went out. What a waste of our time, resources, and money. The community came out saying, we know what went on, but we are delighted. We're delighted for the very first time in our history anyone has taken it seriously, that we've been able to, and the discussion we had as a community and how we wanted to approach this had a very positive impact on. In terms of the British had never taken them to, and no one had ever spoken to them in Nairobi. The Kenyan authorities, government since independence in the early 60s, had never spoken to them. So this was sort of a very positive step. So it was very interesting that we said, from a lawyer's point of view, this was a terrible meeting, but from the community's point of view, it was a much more positive meeting. And then the inevitable government pushback came, which was, fortunately, this was just a year or so before the real election violence erupted in Kenya in 2007 to 8. But fortunately, it was very little violence, but it was to accuse the leaders of the Welfare Council and others of being corrupt, of all this money that was coming in from their lawyers, etc. But that's where the organisation of the community really mattered, because they were elected, because they were accountable to their community. the community didn't go along with this at all, and as a community weren't intimidated. Also that we as NGO, and again, stressing it too much, but then with our limited budgets, that it was absolutely vital, particularly around this stage. We went and did meeting after community meeting for some time with groups of NGOs, and went around and said, this is what it means. To say it will not mean, even if you win, that the land will come back tomorrow. But really a long discussion, and that really mattered to say these were not just some more people a long way away. And also to understand what they wanted, particularly on this. One other thing briefly before the final hearing is that we also had, you decided to use a video. There's still a great organisation based in New York called Witness, which was set up by Peter Gabriel, the singer, about 20 years ago. There was a case called Rodney King, actually, when someone was Los Angeles police officers were caught on video attacking a citizen. But out of that was an idea that we're going to set up an organisation to provide video evidence for court cases, and it actually gone international. And they came to us and said, do you have any case that would be useful to this actually wanted to get information to show what the community is like to this commission in the Gambia. So and they've had a great project, which is when they took this in, they would work with the community for weeks to take hours and hours of video and interviews with people, and also train people and members on how to both shoot and edit, which is obviously very key to put hours down to 7-minute video, which is going legal point by legal point. And again, the community said this is much, much bigger than just getting that 7-minute video. This is the first time anyone's recorded our history, because to go for the land case to show the history of the community and why they lived there, these were hours of video. So eventually, having not agreed anything with the Kenyan government, we come back for the final hearing. And to show that certain ways of doing things, despite everything having been agreed some months before, they still said, oh, but do you have a hearing? And my certain colleague was speaking to, now, as you said many times, the Algerian commissioner, and said in front of me, Monsieur, ce n'est pas une séance, je vais pleurer, which means, if there's no hearing, I'm going to cry. And that got the hearing, because of knowing, having spent years and years going to that commission, knowing the people, and saying, this is the absolute key point. We may not have been able to afford to have another hearing. And we had the key witness, we only had 2 witnesses, the leader of the community, of the Welfare Council, and the leading professor of law, of land law in Kenya, but actually I think in Africa at the time, who was called Professor Okofogendo. He'd been teaching and writing on land law across Africa, especially in the University of Nairobi, since the 60s, and had written what's now in the Constitution, the section on land law. He was in his 80s, so we had to get him there carefully, but he was there, and we had the hearing finally. I had 2 moments, just briefly on it, to show the Kenyan government's response was really only twofold that I remember. One, they still wanted to keep denying that the NGOs existed as a community, let alone the Indigenous, that they didn't exist, they were made up, that they, and with all the labelling that goes on in Kenya, these were just a few people out for some money. And that's why having the leader of the community there, the Welfare Council, and having the video to show all the different ways they were doing. And once we'd shown a video, the government demanded to have a video. So they made a video which was just 2 members of the community going around saying everything else, everything they claim is a bunch of lies. At one point they interviewed a chief, and in Kenya mostly the chiefs were people imposed by the British a while ago and paid by the British, and that's continued in the state where they're essentially paid by the Kenyan state. But he was speaking in Swahili with subtitles, and the subtitles said something denouncing our claim. But there was a Tanzanian member of the African Commission who said, who was watching, said, "Stop, rewind." And he said, "No, the subtitles are completely wrong." He's saying actually the opposite. He was defending our case. That was one good moment. An even better moment was when we had Professor Ogendo in the room. And the leading lawyer for the Kenyan government, she was very aggressive all the way through. She's probably one of the most senior lawyers working for the government. But they were asked a question about Kenyan land law. And she just said, "I cannot answer that question when my professor's in the room." And he was the person who taught everybody, including them, land law. So he said, "Yeah, I'll answer that." And he answered it, again, in our favor. So we did leave quite positive after that hearing. It then took 2 years, and it's not a tribunal, it's not a court, it's a commission. It has many other things to do, and there's lots of complications, which I won't go into, including the lawyer on the court, on the commission, leaving after 8 years. Another key point, though, is knowing how all these tribunals, international bodies, work in different ways. The key in the African Commission, which I tell anyone who's litigating this, first of all, go there, understand it. If you can find any reason to justify actually being there, especially as your case is being built up, know it, because you need to know who is the lawyer on your case in the tribunal, who is the rapporteur, the member of the commission, they're essentially judges. The rapporteur in our case, Sanji Monahan, who's from Botswana, is now the vice president of the International Criminal Court, so having done our judgment. So in the end, the judgment came out, it's 2010, and the community won on every single point, all these points, including the right to development. So that's made it sort of key for Indigenous rights in Africa by recognising Indigenous people exist, but the key remains getting the land back. So even I'd left MRG by then, but we'd even then thinking we have to put, even in our limited budget, the money is not just, we don't have money just for litigation. That's only the beginning of the end, or the end of the beginning even. It has to be for implementation. I did remember meeting the lawyer who brought the our Stigny case, which is the first case in the inter-American system, Nicaragua, who was saying, yeah, we won the case, and it took 10 years or so to actually get implemented in Nicaragua, which is about demarcating land. It's infinitely more expensive to do the implementation, and also because you have to not just demarcate but negotiate with all the neighbouring communities. I know Parliament say something this afternoon, but it's, I don't know what to say, but there's it's been ongoing. There was, and very recently, the government of Kenya announced it was setting up a task force to work on implementation. Now, this is obviously a key issue, I would say, for Indigenous rights, especially in Africa, that this community, having won a case where the situation itself can be fairly, compared with many other places around the world, easily resolved. But that this one can be sorted and set the precedent, not just on law, but in practice. But the absolute key all along was the strength of the community, the unity of the community, and the accountability, and that's why I have a lot of respect for Indigenous.
Well, thank you very much. It's really an interesting example, and this is great because we have a few minutes now to take some questions. And then we've changed the format a little. You notice we did not take a coffee break because we thought if we got through our cases, we could then have a nice long lunch, and it would give us more material to consider. So, can I take some questions from the floor?
You mentioned recognition as a community and also steps to get the land back. What about other losses? And I'm also thinking that the thing that really struck me was you talking about the medicines by the lake. So what about loss of knowledge, loss of identity? Is there anything that is being done to sort of redress the results of those interruptions?
I've been less involved in, well, I said much less involved in the last few years about what's actually been done, but what we argued was all those rights, including the right to health. That it would either just need financial compensation for this, which would not just be about the value of the land, or even the dwellings on it, but it was, do they still have access? And that, even that would be very difficult to judge. No one could have documented what the health impact would have been 40 years ago. They could say that they moved away and a lot of their cattle and goats died, not because of the lack of water, but also because of illnesses. And they said it would come from the local plants and trees which grew by the lake and didn't grow anywhere else. And that's the only place they could access it. So that's, to me, it's an even stronger argument for returning them access to the lake and free access there. That had improved a bit, even with the case going. It would be more difficult to put it in purely financial terms if there wasn't an option, particularly of restitution of the land. But it is something we wanted to put in. And similarly, even for that right of development, which is, it lost so much development. We certainly set it out. How you would have to go about quantifying it will be difficult, but it will be necessary in many cases, particularly when there's no possibility of returning the land.
Thank you very much. I probably, just by way of context, I'm going through quite a similar process at the Equal Rights Trust, as it sounds like you were going through at MRG, of trying to start focusing the organisation on litigation a bit more in the really, really strict confines of working on project work and the very limited budgets that we're going through. But I'd love to pick your brains at some point about that in a bit more detail. But in the context of this forum, I think one thing I'm interested to know, and also the context of those confines, to what extent did you rely on pro bono support, or to what extent would pro bono support have assisted in the case? And then maybe something which I know nothing about at all, but from the anthropologist's perspective, is there any role for potentially anthropologists in that task of trying to work through those negotiations at the implementation stage?
Thanks. Pro bono, I mean, very briefly, I found over the years, especially cases like this, pro bono can mean there's extremely dedicated lawyers out there and extremely helpful. It very much works better as a one-off. If you've got one particular thing you need assistance with, as an ongoing issue, it's difficult because what if they have something else going on, they're not working with you, and that actually engagement you have. We did have someone helping us very much at the beginning, then got a different job. So by the end of it, now it would be almost impossible to bring anyone new in because it would take years and years of trying to build it, and especially once you've been and spent time with the community. There's so much it would be very difficult for anyone to share. But pro bono assistant can be very good on very specific issues, like particular, perhaps a hearing on an issue or a particular area of international law. But in this area, there's very little international law either, so it was difficult. As I said, the best assistance I got was from 2 interns at that time. Sorry, what was your second point?
And just I wondered, I mean, I don't know anything about it, but in terms of the implementation phase, which is clearly the most challenging aspect once you've got a judgment, I just wonder in terms of the way that those negotiations are going to happen, in terms of where boundaries are drawn and how it all works, is that something where the type of research that might be required for the implementation phase is something which anthropologists might be involved in?
I'm sure, and we've seen in other parts demarcation. In Kenya, actually has a very good constitution now since 2010, partly I was coming anyway, but since the near genocide of 2007 to 8, I mean, one positive area was put in this constitution in place, and the land section was largely from Professor Ogendo. So as a basis of it, I mean, it says every single land issue since British colonialism in the 1890s would be resolved. It's an absolutely massive issue in Kenya, but it's something where I certainly find this in general human rights work, the wider international community do not put anything like enough resources in. It's something it's money. It's like the lawyer who represented the Alice Tickney in Nicaragua was saying, it's money, but you put the money in and you get clear land rights, which everyone accepts. The reduction for in risk of violence and the ability to develop is much better. I mean, the development discussion is something else. I mean, it's not just individual rights, which is what's legal empowerment to the poor sometimes focus on too much. But it has to be addressing the collective rights of the Indigenous. So it's something, I don't understand development funders much of the time anyway, but why this isn't just seen as a clear area where concrete, significant that one-off support for sorting out land rights in countries like Kenya, which have the basis to do so, would be a great investment.
Well, I really like these two questions because they steer us back to the focus of this forum, as you say, which is exactly to what extent can pro bono assistance be useful, and also how can that be merged with an anthropological recognition of how land is conceptualized and the way in which those conceptualizations and the diversity of ways in which they're conceptualized can be mediated to an effective outcome. Well,
You prevailed at this commission. They gave you a positive result. Do they have the power to enforce it?
No. The only international human rights tribunal which has a success in enforcement is the European Court of Human Rights, which is why 7 states don't like it, including this one. But and Philip was talking about PhD. That's, to me, I've never seen a good research on that as to why that works and that doesn't. For me, working it is because that has peer pressure. The system is the Committee of Ministers, which are the deputies, ambassadors of the Council of Europe, review regularly enforcement. We actually won another case at MOG, which is too complicated, it hasn't been enforced against Bosnia. So that's why even that part I said of the provisional measures with the mining was effectively enforced. You say, how did that happen? It was the media, it was the views of the Kenyan authorities, which have never faced this before, and perhaps didn't know this body, the Commission has no enforcement power at all. So it becomes a regular, to me, as not just as a lawyer, as a human rights activist, the law is a powerful tool, but it's one tool amongst many in advocacy. It then becomes, how do you get a court, treaty as a court ruling put in? Less so whether it's legally binding. I mean, the rulings of the African Commission are technically not binding, but the rulings of the African Court are. I don't think that makes much difference in practice, actually, because it is how it will be perceived in the country. And can whoever is affected mobilize enough support, both in the country and outside? But having a court ruling does make a difference.
but related to what you said about group rights and the distinction between rights of humans and people's rights as they are played out in Africa, I'm assuming that your answer to the question I posed to Philippe would be that you could get more mileage on the group rights issue in Africa than you might in Ecuador or Colombia.
Certainly legally,
Yeah.
The African Human Rights Treaty is partly about people's rights. We had that issue at the beginning where Article 14 in the African Charter, which is the one on property rights, seems to be in the individual rights section rather than the people's, but it actually doesn't say that it can't apply to collective, and the Commission accepted it did. I mean, the arguments that were made in the Inter-American Commission of Court before, where they have to take an individual rights, it also applies collectively, helped, but they started with a weaker treaty of these issues. So the African system has a lot more potential already, because it's already been written in that way.
That's interesting to know. Now we're over time, but can we take one more question before we? Yeah.
I was just wondering how much, if you had worked with anthropologists at all when you were making your arguments, because, for example, it would be very interesting for an anthropologist to look at how their grazing activities have changed, how the household economy completely changed, perhaps the woman became more sedentarized, the man didn't, and just the dynamics and these demographies are really interesting to us. So I was wondering if you used at all anthropologists to build your case.
We didn't in our submission. I'm trying to remember where I did. Thinking about it would have been quite useful, because if I had known, we didn't know what.
It had more than 70,000 pounds.
Yeah, no, more than 70,000 pounds. But we thought it'd be about property, and that is the core of the case. If the government would have denied the existence of the community to that degree, there's other evidence that could be got through anthropologists. I have to say, there's a lot I wasn't familiar with anthropology at all, so it wasn't something that crossed my mind at the beginning. But we just had to rely, for the community itself, just on the evidence of the leader of the Welfare Council and say, we exist. and some of the video evidence.
Because, for
Yeah.
example, property is directly related to their economic activities because of grazing, because of nomadic lifestyle. I don't know if they're transhuman
Yeah.
or. So, I mean, it would be really interesting. Next time, give us
Yeah.
a call.
And
Future professional.
And actually, anthropology and this right to development could be also quite an interesting area. I mean, what does it actually mean? And both, as I said, the academic work wasn't particularly helpful, but that was done by legal academics at the beginning. But I had to say, what does it mean in practice? What's harm? How should the community make its decisions about what development is?
Thank you very much, Clive. This was really interesting, and we'll be building on these presentations and papers throughout the day. Great job.
Thank you.